Very good day to everyone. So today we are going to continue with the next part under under contract law, which is the capacity to contract. Okay, so uh, this is one of the basic requirement for valid and enforceable contract. Okay, so under Section 10, subsection 1 of Contract Act 1950, it states that all agreements are contracts if they are made by parties competent to contract. This simply means that for an agreement to become a valid contract, the people entering into the agreement must be competent. Or in other words, they are legally capable of making the contract. So you might ask, what does competent to contract means? Now, the law requires that parties must have a legal ability to enter into the contract. If a person is not competent, then the contract cannot be enforced in court. And why is this important? Because the law wants to protect certain groups of people from being taken advantage of, especially those who may not fully understand what they are agreeing to. So let me give you an example. A minor who cannot enter into a contract. Now, minor means that he is not reached the age of majority yet. Okay, we are going to look at it later on. Now, in this example, let's say that Ali is 16 years old and he signs an agreement to buy a motorcycle. Even if he signs it clearly, the contract is not enforceable because Ali is not competent to contract. Now, under Malaysian law, a person must be 18 years old to enter the contract. In the example just now I've given you, Ali is only 16 years old. So, based on Section 10, subsection 1, a contract is only valid if all parties are competent. If a party is not competent, the agreement cannot be enforced in court. Competency is one of the fundamental requirements in contract formation. Right? So let's continue. Now, competence to contract, okay, to form a valid contract, the people entering into the contract must be legally competent. This means that they must have the legal ability to enter into an agreement and understand what they are agreeing to. So what is capacity? So capacity simply means the ability of a person to fully understand the term, responsibilities, and consequences of the contract. If someone does not understand the contract due to age or mental condition or legal restrictions, then they do not have the capacity. So under Section 11 of the Contract Act 1950, here Section 11 explains who is competent to contract. It states that every person is competent to contract who is, number one, of the age of majority, number two, of sound mind, and number three, not disqualified by any law to which he is subject. So let's break down these three requirements in a simple way. So when we talk about age of majority, it means to be competent. A person must be 18 years old and above. That is the age of majority in Malaysia. So example, Sarah is 17 years old and signs a contract to rent a house. Now, she is not competent because she is a minor. The contract is not enforceable. Okay, that is age of majority. Next, sound mind. A person must be mentally fit and able to understand what the contract means, what they are agreeing to, and the consequences of the agreement. Example, if John suffers from a mental illness and is having an episode where he cannot think clearly, and at that time he signs a contract, then we say John is not of sound mind at that moment. The contract may be invalid. Another example, someone who is extremely drunk cannot understand the contract they sign. So he is not competent at that moment. I hope you understand that, yeah? Let's continue. The next one is not disqualified by any law. Now, certain individuals may be legally restricted from entering the contract. Examples like a bankrupt person may not be allowed to enter certain financial contracts unless given permission. Or the government of officers may be restricted from engaging in business contract without approval. If the law restricts a person, then he means they lack capacity and the contract is not valid. Okay, so for easy understanding, a person must be competent to contract only if, number one, they are 18 years old or above, number two, they are of sound mind, and number three, no law disqualifies them. If any one of these conditions is missing, then the person does not have the capacity and the contract cannot be enforced. Okay, so I hope you understand that. This is the age of majority, which is 18 years old, and the person of sound mind and person who is not disqualified by any law. Let's continue. Now, here we are going to looking at the minor. Okay, so basically, the age of majority, as we have discussed just now, is 18 years old and above. So if you are 18 years old and above, means that you are adult and you can enter into any contract. Now, a person must be at least 18 years old to enter into a valid contract. Okay, and then a person of a sound mind just now, okay, he must be mentally stable and fit. And the third one is person who is not disqualified by law. It means that he is not restricted by any law to prevent them from entering the contract. Yeah, okay, now, let's continue. A minor. Now, who is a minor? A minor is someone who has not yet reached 18 years old. This means anyone who is 17 years and 364 days old is still considered a minor under the law. Okay, so the law on age of majority, according to Age of Majority Act 1971, a person becomes an adult at the age of 18 years old. Only at this age can a person enter into a legally enforceable contract. Okay, so for easy example again, if Ali is 17 years old and signs a contract to rent a house, the contract is not valid because Ali is still a minor. But if Ali is 18 years old, then the contract is valid and enforceable. So you might ask, why does the law treat minors differently? Because the law tries to create a balance when dealing with minors. There are two main principles. Principle number one is to protect the minor. The law protects minors because they usually have less experience. Okay, they do not fully understand the consequences of a contract and they can be easily influenced or misled. So easy example, a shop sells a 5,000 watch to a 15-year-old student. So the law protects the minor because they may not understand the financial responsibility. Okay, so number two, the principle number two is avoiding hardship to adult who deal with the minor. Okay, so while protecting the minor, the law also wants to be fair to adult who deal with them. This means people who deal with minor should not suffer unfair hardship, but they must still be responsible and careful when entering agreements with minor. An example, a minor books a hotel room and disappear without paying. The hotel should not suffer unnecessary losses, but the contract still cannot be enforced if it's not a necessity. So, for summary, a minor is anyone below 18 years old. A minor cannot enter a valid contract except for special situation, examples like necessities. The law aims to protect minors from being exploited and avoid unfair burden on adults who deal with minors. Now, let's look at the effects of contract by minor. Now, according to Section 10, subsection 1, and Section 11 of the Contract Act 1950, a minor who is a person below 18 years old is incompetent to contract. This means a minor does not have the legal capacity to enter into a contract. Therefore, any contract made by a minor is void. Void means the contract has no legal effect from the beginning. Batal, void. Yeah. Now, so what does it mean when the minor's contract is void? Then, since the contract is void, it cannot be enforced in court. This leads to three important points. Number one, a minor cannot be made liable. Okay, if a minor enters into a contract and later refuses to perform it, then the minor cannot be forced to pay or perform the contract. Number two, a minor cannot be sued. If a minor fails to fulfill the agreement, the other party cannot sue the minor for breach of contract. Number three, a minor cannot sue to enforce a contract. Because the contract is void, so the minor also cannot sue the other person for not performing the agreement. Okay, so for your easy understanding, a minor's contract is not valid, not enforceable, minor cannot be sued, minor cannot sue, minor is not liable. Okay, because the law wants to protect minors from their lack of experience and prevent them from being exploited. So let's look at a case, Mohori Bibi versus Durmodas Goose. Okay, so fact for the case, in this case, the minor, who is Durmodas Goose, he entered into a loan agreement. He borrowed money and even mortgaged his house as security for the loan. However, an important detail is this. The loan giver already knew that Durmodas was a minor when the contract was made. Later on, the minor's mother, acting as his guardian, went to court. She asked the court to declare the contract void because the borrower was a minor and did not have legal capacity to enter into the contract. So the issue of this case is that, is the loan agreement valid even though the borrower was a minor? So the court held says that the agreement is void. The contract is not binding on the minor. The minor cannot be held liable. So the court confirmed the general rule where a minor cannot enter a legally enforceable contract. So why this case is important? Because this is the leading case on minor's contract. It clearly shows that a minor cannot be made responsible for a contract, even if the minor takes money or benefits from the contract. The contract is still void. Adults have the responsibility to check whether the person they are contracting with is a minor. Okay, so I hope you understand this particular case. So let's continue. Another case, Tan Hee Juan versus Tae Boon Kiat. Okay, so in this case, a minor who is Tan Hee Juan entered into a contract to transfer land to the defendant, Tae Boon Kiat. Okay, after the agreement was made, the minor, through a legal process called PF ataupun personal representative ataupun next friend, applied to the court to cancel the contract, arguing that he was a minor and therefore had no capacity to enter into the agreement. So the issue of this case is a land transfer contract valid when it is signed by a minor? So the court held that, says that the contract was void because the minor lacked legal capacity. Therefore, the contract is not binding on the minor. The land must be returned to the minor. So this follows the general principle under Section 10, subsection 1, and Section 11 of the Contract Act 1950, where a minor cannot enter into a legally enforceable contract. So why this case is important? This case reinforces that rule that contract involving immovable property like land, okay, immovable property, examples like land are void if entered into by a minor, even if the minor agreed, signed, or participated voluntarily. The law still protects the minor. It also shows that courts will restore the minor's property, ensuring that the minor does not suffer loss. Okay. Okay, let's continue. All right. So, exception to the rule when minor contract is valid. Okay. So, the general rule in Malaysia is that any contract made by a minor is void. This based on Section 10, subsection 1 and Section 11 of the Contracts Act 1950. However, there are certain situations where a minor can enter a valid and enforceable contract. So these situations are called exception. Okay, so what are the exceptions? So below are the 5 exceptions shown in your slide. The first one is contract of necessities, sorry. So a minor can be held responsible for contract of necessaries. Necessaries means things the minor needs for daily life, such as food, clothing, education, medical services, and shelter. Okay, example, a 17-year-old gets medical treatment at the clinic. Even though he is a minor, he must pay for the treatment because it is a necessity. Okay. Number 2, contract of scholarship. Now, under the Malaysian law, Scholarship Agreement Act 1950, scholarship contracts signed by minors are valid and enforceable. Example, a minor receives a government scholarship and signs the scholarship bond. The agreement is valid and the minor must follow the condition. Number 3, contract of insurance. Certain insurance contracts entered by minors, usually with parental or guardian consent, are recognized as valid. The law allows minors to take insurance for their protection or education. Example, a 17-year-old buys an educational insurance plan with guardian approval. The contract is valid. Number 4, beneficial contracts. A minor can enter a contract if the contract is clearly for the minor's benefit, which is not harmful or risky. So these include contracts of apprenticeship, training contracts, employment contracts with reasonable condition. For example, a 16-year-old joins a training program as a trainee mechanic. So the contract is beneficial and therefore it is valid. The last one is contracts under the Age of Majority Act. So the Age of Majority Act 1971 allows certain types of contracts involving marriage settlement, adoption, and religious or ceremonial matters. So these may involve minors and are recognized under specific legal rules. For example, a minor receiving property through a marriage settlement is valid because it is allowed under the Act. So for summary, for your simple understanding, most contracts with minors are void, but these 5 types of contracts involving minors are valid. Number 1, necessaries. Number 2, scholarship. Number 3, insurance. Number 4, beneficial contracts. And the last one is contracts allowed under the Age of Majority Act. So let's go through one by one. What are necessaries? Okay, so we are going to look at Section 69 of the Contract Acts. Necessaries are items or services that are essential to the existence of the minor and provide reasonable comfort appropriate to the minor's lifestyle and condition in life. They must be things the minor genuinely need, not luxury. Examples of necessaries are food, clothing, basic shelter, education, medical treatment, books or tools needed for study. So these items help the minor to survive and live with reasonable comfort. So when is the minor bound? Where even though minors normally cannot be bound by contract, they can be liable for contracts involving necessaries. But this only applies if the items are truly necessary for the minor. If the contract is harsh, unfair, or oppressive, then the minor will not be bound. So the law says, if the minor needs it, they must pay for it. If the minor does not need it, or it is too expensive or unfair, they do not have to pay. This rule protects minors, but also protects people who supply essential goods or services to minors. Okay, so again, let's take an example, medical treatment just now. Okay, a 16-year-old goes to a clinic for urgent medical treatment. So here, in this example, medical care is necessity. So the minor must pay for it. Okay. Another example, a minor buys a school uniform. Is it necessities? Yes, because it is essential for education, right? So the contract is valid and the payment is required. Now, another example, luxury item, which is not necessity. Examples like a 17-year-old buys a 4,000 ringgit branded shoe. Now, this is a luxury, not necessity. So the contract is void. The minor does not need to pay. Okay, so simple summary for you. Necessaries are things essential for living and comfort. Minors can be required to pay for necessaries. Minors don't have to pay for luxury, unnecessary items, or unfair contract. Now, here, let's continue. Necessary is not clearly defined in the Act. Okay, in the Contract Act 1950, it does not give a strict definition of necessaries. However, in Section 69 guides us by saying that whatever is supplied to a minor must be suited to the minor's condition in life. This means the item must match the minor's lifestyle, background, and needs. Example, a basic laptop for studying may be necessity for a college student, right? RM 10,000 ringgit gaming laptop is not a necessity for the student. So what counts as necessary depends on the minor's situations in life, okay? So what counts as necessaries? According to the principle, necessaries can include goods. These are physical items needed for daily life, such as food, clothing, books, or medicine. Okay? Number two, articles. These include items for minor needs for schooling or living, such as school tools, study materials, basic household items. Okay, that is articles. Next is services. These are services reasonably necessary for the minor's actual needs, like medical treatment, tuition or education services, transportation for school, essential housing, or leading or lodging. Okay. So necessary depend on each case. What is considered necessary is not the same for every minor. It depends on the minor's background, the minor's current needs, the minor's lifestyle, the minor's social and economic status, the circumstances at the time of the contract. I'll give you an example, okay? Understanding the different circumstances. Minor A, okay? So A comes from a rural area, dari kampung, and needs a simple school uniform. So the uniform is a necessity. The next one is B, minor B. So B comes from a wealthier family, anak orang kaya, and needs a private tutor for specific subject. The tutoring service may be a necessity given their condition in life. Okay, so for your summary, Section 69 doesn't fully define necessaries, but it must be suitable and essential based on the minor's lifestyle. Necessaries here include goods, articles, services needed for reasonable comfort and survival. So what counts as necessary depends on each case. There is no fixed list. All right, let's continue. Looking at Section 69 of the Contract Acts. Here it explains how a supplier can be reimbursed when they provide necessaries to a minor. However, the supplier must fulfill certain conditions. If these conditions are not met, the supplier cannot claim payment from the minor. So below are the conditions explained. Okay. Condition number one, the necessaries must be actually be supplied to the minor. It is not enough for the supplier to just agree to supply. The goods or services must be actually delivered or actually used by the miner. Example, a shop agrees to sell school uniform to a miner but never delivers them. So the shop cannot claim payment because nothing was actually supplied. Condition number two, liability extends to those the miner must support. In section 69 also states that the liability includes necessaries supplied to any person the miner is legally bound to support. This applies to special situations such as if the miner is responsible for a spouse or a child. Okay, I give you an example. If a miner legally has a child, which is very rare in Malaysia, who needs food or medicine, and supplier provides these necessities, so the miner can be liable to reimburse the supplier. In condition number three, the supplier can claim only a reasonable price. The supplier cannot charge excessive amounts, inflated prices, or the full contract price if it is unreasonable. The supplier must provide, number one, the goods or services are suitable to the miner's lifestyle. And number two, the goods or services meet the actual need for the miner at the time of supply. Example, a miner needs a pair of school shoes. The reasonable price is 80 ringgit. However, the supplier charged 300 ringgit. Now, the court will not force the miner to pay 300 ringgit, okay? Because the supplier can only claim the reasonable amount, which is 80 ringgit. Yeah, I hope you understand that. Condition number four, miner is personally liable only if he has property. In section 69 creates quasi-contractual liability. This means the miner does not become liable like a normal adult. Instead, the miner is liable only if he has property, such as money or assets. Payment is limited to the value of that property, and the miner is not personally responsible beyond his assets. Okay? So I'll give you an example. A miner receives 500 ringgit monthly allowances and buys necessary medicine. Payment can be taken from this allowance, but if the miner has no money or no property, the supplier cannot force the miner to pay. So, a simple summary for you. To claim payment under Section 69, the supplier must show, number one, goods or services were actually supplied. Number two, they were necessaries for the miner or someone the miner must support. Number three, the price claimed is reasonable. And the last one, the miner has property to pay from. So if any condition is missing, then the supplier cannot claim a reimbursement. Let's continue. Looking at this case, governments of Malaysia versus Gujarat Singh. Okay, so the fact of this case, so in this case, the governments of Malaysia, which is the plaintiff, sue Gujarat Singh, the defendant, for breach of contract. The government had spent 11,500 ringgit, okay, to educate and train the defendant so he could qualify as a teacher. However, at the time of training contract was made, the defendant was a minor. The government claimed the money back because the defendant did not fulfill the agreement. So the issue of this case is that since the defendant was a minor, is the training contract valid or void? If void, can the government still recover the money spent? So the court held says that number one, the contract was void because the contract, uh, because the defendant was a minor, okay, when he entered into the agreement. Under the general rule, minors cannot enter into valid contract. However, but the minor was still liable to pay the money. Why? Even though the contract was void, the contract held that the minor still must repay the 11,500 because the education and vocational training provided by the government were considered necessaries under Section 69 of the Contract Act. So education that helps the minors secure a livelihood is recognized as a necessary. Therefore, the supplier can claim reimbursement. This is an exception to the general rule. So what is the meaning of the decision? The case shows that some things given to a minors are so essential to their future, like education, training, or professional education. But even though the contract is void, the minor must reimburse the reasonable cost of those necessities. The law does this to avoid unfair loss to the person who provided the necessities. Okay. Now here, even though the minors can be held liable for necessities under Section 69 of the Contract Act, not everything supplied to a minor counts as necessaries. Okay, there are situations where the goods are no longer necessaries but become luxuries. When this happens, the minor is not bound by the contract. So when are extra goods considered luxury? So a key principle is if a minor has already been adequately supplied with certain goods, any additional or extra goods of the same type become luxury, even if the goods are normally considered necessities. This is because the law does not allow suppliers to take advantage by oversupplying a minor. Okay, so let me give you an example. Clothing. Clothing is normally a necessary, but if a minor already owns 5 pairs of uniform and the shop sells him 3 more expensive uniforms, then the extra uniforms are considered luxury. So the contract is void. The minor does not need to pay. Okay, so the legal effect. Once the goods are considered luxury, the law says the contract is void. The minor is not bound. The supplier cannot recover any payment. This protects minors from being oversold unnecessary goods. This rule helps prevent exploitation and ensures minors only pay for what they are truly need. So, simple summary for you. Necessaries are essential items for life and reasonable comfort. But if the minor already has enough of these items, so the extra ones becomes luxury. When goods becomes luxury, the contract is void. Minor does not need to pay. Right? So let's look at the case. Nash versus Inman. So in this case, the plaintiff was a tailor who supplied clothing to the defendant, who was a minor. So the clothing included 11 fancy waistcoats, items that are stylish, decorative, and clearly not everyday essentials. After supplying the clothes, the plaintiff demanded payment for the goods. However, the defendant refused to pay. The defendant argued two main points. Number one, he was a minor at the time of the contract. Number two, the clothes were not necessaries because he already had enough proper clothes supplied by his father and according to his lifestyle and condition in life. So the issue of this case is that were a fancy waistcoat considered necessaries under contract law so that the tailor could claim payment? So the court held says that the clothes supplied were not necessaries and they were not required for the defendant's actual needs. The defendant already had sufficient clothing for his conditions in life. Therefore, the defendant was not bound to the contract and the tailor could not recover the price of the waistcoats. So why this case is important? Because this case highlights two key principles. Number one, necessaries depends on actual needs. Even if an item is normally necessaries, it will not count as necessaries if the minor already had enough. Number two, extra or unnecessary goods, which is the luxury, fancy, decorative, or duplicate items are considered luxury, not necessity. Therefore, contracts for such items are void against a minor. So simple summary for you, minor who bought 11 fancy waistcoat, he already had enough clothes, which is not a real need. The waistcoat was only a luxury for him, which is not a necessary. So the contract is void and the minor is not liable. This case shows how the law protects minor from overspending or being exploited. Yeah? Next is the contract of scholarship. Normally, contracts made by minors are void and cannot be enforced. However, scholarship contracts are an important exception in Malaysia. This means a minor can enter into a valid scholarship agreement, and the agreement can be enforced even though the student is under 18. So under legal basis, this exception comes from the Contract Act 1976 amended. Okay? According to the Act, a scholarship agreement entered into by a minor is valid and enforceable when the scholarship, bursary, award, loan, or scholarship is given by the federal government, the state government, a statutory authority such as MARA or JPA, or an educational institution such as the universities. This law protects scholarship providers and ensures students honor the agreement. So why are scholarship contracts valid? The government created this exception to encourage education, to protect the public funds, to ensure students complete their studies, and to prevent minors from abusing the scholarship. So if a minor signs a scholarship agreement, the contract is valid. The minor must follow all conditions, and the provider can take legal action if the minor breaches the agreement. This is different from normal contract, which would otherwise be void when signed by minors. Okay? So summary for you in this particular slide, that scholarship contracts are valid even if signed by minors. This is allowed under the Contract Amendment Act 1976, applies only when the scholarship is provided by the government, statutory body, or the educational institution. Minors must follow the bond or condition of the scholarship. Next is the contract of insurance. So the general rule here is that under the normal contract law rule, minors cannot enter into a valid contract. However, insurance contracts are special exception in Malaysia. Insurance is considered important for a minor's future protection. So the law allows minors to participate with condition. Number one, it is governed by the Insurance Act 1963. The law provides two age categories: minors over the age of 10. A minor who is over the age of 10 may legally enter into an insurance contract. These include insurance such as life insurance, education insurance, medical insurance. This is because insurance is beneficial and protects the minor. Next one is minors below the age of 16. If the child is under 16 years old, the law requires written consent from the parents or guardian. This means the minor cannot buy insurance alone. The parent or guardian must give approval in writing. Why written consent needed? Because insurance involves long-term payment. There may be financial risks, and the minor might not fully understand the consequences. So written consent ensures that the parent or guardian is aware and agrees to the financial commitment. So summary for you in this particular slide is that insurance contract involving minors are an exception to the general rule. Over the age of 10, they can enter insurance contract. Below the age of 16, they must get written consent from the parents or guardian. Insurance is allowed because it is beneficial to the minor. Now let's look at this beneficial contract. What are beneficial contracts? A beneficial contract is a contract that gives a clear benefit to the minor. This benefit can be education, training, employment, learning a trade or profession, or skills development. If a contract helps improve the minor's future, then the law may consider it binding, even though minors normally cannot be bound. Why? Because the law wants to protect minors, but also wants to support opportunities that help minors grow, learn, and earn a living. Now, when is a minor bound by a beneficial contract? A minor is bound if the contract, number one, is for the minor's benefit. Next, helps the minor develop skills, training, or trade. Number three, does not exploit or harm the minor. And the last one, it is reasonable and fair. If the contract is good for the minor's future, the court will enforce it. Let's look at this case, Doyle versus White City Stadium Limited. The fact of the case, Doyle was a professional boxer, but he was still a minor. To get a boxing license, he entered a contract with the boxing board. Under the contract, the board could withhold prize money if Doyle was disqualified. During a contest, Doyle was disqualified and the board withheld his prize money. Doyle then sued the board saying, "I am a minor. The contract is not binding on me, so I should get the money." So what is the issue of this case? Was the contract enforceable even though Doyle was a minor? So the court held says that Doyle lost the case. The contract was binding on him. It was considered a beneficial contract of employment. Why? Because the license allowed Doyle to earn a living as a professional boxer. The contract was fair and necessaries for him to work professionally. The condition, such as withholding prize money, were reasonable and part of professional rules. Therefore, the contract for Doyle's benefit. So it was binding even though he was a minor. So why is this case important? This case shows that not all contracts with minors are void. Contracts that help a minor develop a career or skill can be enforced. Courts will protect minors and support beneficial opportunity. So summary for you in this particular case is that beneficial contracts help minors learn or develop skills. Minors can be bound by such contract. Doyle versus White City Stadium Limited confirms that employment or training contract that benefits minors are enforceable. Now let's look at Section 13 under Children and Young Persons Employment Act. Okay, so under normal contract law, minors usually cannot be bound by contract. However, the Children and Young Persons Employment Act provides a special exception. Minors can enter into a contract of service or employment contract, especially when it involves training or apprenticeship. This is allowed because employment and apprenticeship helps minors gain skills for their future. Now in Section 13, what does it say? Section 13 states that a minor can enter into a contract of service. This means the minor can be employed, enter apprenticeship, receive vocational training, and undertake service agreement, so long as the work is suitable and safe. So, looking at the definition of child and young person, the law divides minor into two groups. Child, any person below 14 years old. Young person, a person between 14 and 16 years old. This is important because the law places different limits on what each group is allowed to do. What are the rights under this act? A minor can sue or be sued under a contract of services. This means if the employer breaks the contract, the minor can sue the employer. If the minor breaks the contract, the employer can sue the minor. This is different from normal contract law where minors cannot actually be sued. Enforceability of the contract. A contract of service can be enforced by the minor and against the minor. But there is one condition, very important, where the contract must not be unfair or unreasonable. If the employer tries to impose harsh terms, dangerous work, unfair penalties, or unreasonable hours, then the court will not enforce the contract. These protect minors from exploitation. So, summary for you in this particular slide is that Section 13 allows minors to enter contracts of service or apprenticeship. A child is under 14. A young person is 14 until 16 years old. Minor can sue and be sued under this act. Contract is enforceable unless it is unfair or unreasonable. Let's look at this particular case, Di Francesco versus Barnum. So the fact of this case, in this case, plaintiff entered into a contract of apprenticeship with a minor. The contract had several strict terms. Number one, the minor was not allowed to marry. The contract tried to control the minor's personal life. Number two, the minor would receive some payment for performances, but there was no proper provision for her salary or remuneration. This means the minor was required to perform, but her earnings were not clearly protected. Number three, the minor could not dance professionally for anyone else without the peace condition, plaintiff consent. Okay, this condition restricted her freedom to work elsewhere and improve her income. Overall, the contract gave too much power to the employer and too little protection to the minor. So what is the issue of this case? Was this apprenticeship contract binding on the minor, or was it too harsh and therefore unenforceable? So the court held says that the contract could not be enforced against the minor because the terms were unreasonably harsh and unfair. The contract did not truly benefit the minor. Although contracts of apprenticeship are normally considered beneficial contracts, in this case, the minor's freedom were restricted. The payment terms were unclear. The employer gained too much control, and the minor receives very little benefit. Therefore, the court protected the minor and refused to enforce the contract. So why is this case important? This case teaches an important principle where a contract with a minor is only enforceable if it is fair and beneficial. Even if the contract involves training or employment, the court will not enforce it if it is harsh, it is restrict personal freedom, it lacks proper payment, it favors the employers too much, or it does not genuinely help the minor. So these protect minors from exploitation. So summary for you in this particular case, apprenticeship contracts may be valid only if beneficial to the minor. The contract in this case was oppressive, unfair, and restrictive. Therefore, the court refused to enforce it. The case protects minors from unfair employment apprenticeship. Now, contracts made under the age of Majority Act. Normally, minors cannot enter into binding contract. However, the Age of Majority Act 1971 provides specific exception. One important exception involves contracts relating to family matters such as marriage, divorce, dower, and adoption. So these matters are treated differently because they involve personal status, which is not commercial transaction. So in section 4A, it says that nothing in this act shall affect the capacity of any person to act in matters of marriage, divorce, dower, and adoption. Meaning, even if the person is below 18, they still have legal capacity to enter contracts related to these matters. So contracts of this nature are not void, even if one or both parties are minor. So what is the effect of this section? A contract of marriage made by minors or made by their parents on their behalf is valid and binding. They can sue or be sued. Minors can take legal action or be taken to court for matters relating to breach of promise to marriage, marriage arrangement, arrangement related to dower, or marriage settlement. This is a unique exception because it is normal contract law, where minors cannot sue or be sued for breach of contract. But in family-related agreement, minors have legal capacity and the contract is enforceable. Okay, so for simple summary for you, under section 4A, minors have capacity in marriage, divorce, dower, or adoption. Contract in these areas are valid, not void. Minors can sue or be sued for breach of promise or family-related agreements. This exception exists because such matters involve personal status, not commercial exchange. Let's look at this case. Rajeshwari and Anor versus Balakrishnan and Ors. Now, the fact of this case, both parties involved were Ceylonese Hindus. A marriage agreement was made by the parents on behalf of the plaintiff and the defendant. Under this marriage agreement, if either party broke the terms of the agreement, there would be a penalty of $5,000. Later, the defendant refused to perform or to continue with the marriage agreement. Because of this refusal, the plaintiff sued the defendant. The plaintiff asked the court to order the defendant to pay $5,000 penalty. The defendant argued the contract was not binding because plaintiff was a minor. So what is the issue? Is a marriage-related contract valid when one or both parties are minors? The court held says that the contract is binding because contract of promise of marriage made by minors are valid. So under Section 4, subsection A of Age of Majority Act 1971, this is because the Age of Majority Act states that matters related to marriage, divorce, dower, and adoption are not affected by minors' age, meaning minors have legal capacity in this matter. Therefore, the defendant must pay the penalty and the marriage agreement is valid and enforceable. So why is this case important? This case confirms that contracts related to marriage are valid, even if entered by minors, because family and personal status matters fall under special legal treatment. A minor does not improve. The minor's age does not remove their legal capacity. A promise to marry is legally enforceable when it is falls under cultural or personal law agreement. This case is a strong example of one of the exceptions to the general rule that minors cannot enter contract. Let's continue. Just now we discussed very much on minors, and now we move on to the next one, which is talking about mental disorder and drunkenness. Okay. So here, the general rule, a contract made by a person who is temporarily incapable of understanding what they are doing because of mental illness, drunkenness, or drugs is still valid. This means the contract is considered valid unless the person can prove certain things. So when can the contract be invalid? The person with mental disorder or drunkenness must prove both of the following. Number one, he did not understand the nature of the contract, means he did not know what he was signing. He did not understand the meaning or consequences. His condition prevented him from thinking clearly. Number two, the other party knew or ought to have known about his disability, meaning the other party realized he was drunk, mentally unstable, or under the influence, or a reasonable person in that situation should have noticed. If both conditions are proven, then the contract becomes voidable, meaning it can be cancelled. So if this cannot be proven, then the contract remains valid. Right? Next is on the ratification or approving the contract later. Now, even if the contract was made while the person was drunk, mentally disordered, or drug impaired, the contract can still become binding later. This happens when the person regains the ability to understand and then confirms or ratifies the contract. Ratification can be expressed verbally or in writing, or implied by action. For example, continuing payment or accepting the benefit. Okay? So simple summary for you in this particular slide. Contracts made during mental disorder or drunkenness are valid. They only become invalid if the affected person can prove they did not understand the contract and the other party knew about their condition. If the person approves the contract letter when sober or stable, then it becomes binding. All right. So let's look at Section 11 of the Contract Act. Now, Section 11 provides that every person is competent to contract if the person is of sound mind. This means a person must have the mental ability to understand what the contract means and know the consequences and make decisions rationally. If a person cannot understand what they are agreeing to, they are not of sound mind and therefore not competent to contract. Now, under Section 12.1, what is sound mind? In Section 12.1 explains clearly what sound mind means for our contract purposes. A person is said to be of sound mind if, at the time of making the contract, the person is capable of understanding the contract and the person is capable of forming a rational judgment about how the contract affects their interest. Important point for you to understand here is that the law focuses on the person's conditions at the exact time the contract is met, not before, not after. So, breaking down the two requirements just now, right? Number one, must be capable of understanding the contract, means the person must understand what they are agreeing to, what they will gain or lose, and their responsibility. Number two, must be able to form a rational judgment. The person must be able to think logically about whether the contract benefits them, whether the contract harms them, or whether the terms are acceptable. If a person cannot think clearly due to mental disorder, illness, drugs, or intoxication, then they may not be of sound mind at that moment. Okay, so Section 11, a person must be of sound mind to be competent to contract. Section 12.1, sound mind means the person can understand and judge rationally the effect of the contract at the time they make it. If the person cannot meet these two requirements, means the contract may not be enforceable. All right. So, looking at the illustration, okay, Section 12 of the Contract Act explains what it means for a person to be of sound mind for the purpose of making the contract. The Act includes illustrations to help us understand real-life situation. Okay, so illustration A, it deals with mental disorder. Illustration B, it deals with temporary incapacity. When examples like fever or drunkenness. Yeah, right. So under illustration A, again, person with mental illness has clear periods and can contract during the clear periods. Under illustration B, normally sane person, waras, yeah, temporary incapable, contoh having fever, extreme drunkenness, where they cannot contract during the period. Okay. Now let's look at here. The Contract Act 1950 does not clearly state whether the contract made by insane or drunken person is void or voidable. Okay, so the two views exist. The courts normally consider two views when deciding such case. Number one, the general rule under Section 12 on the mental capacity. And then number two is on the English law view based on Imperial Loan versus Stone. Okay, so the English law view means a contract made by a person of unsound mind, which is mental illness or extreme drunkenness, is voidable, not void. But it is only voidable if two conditions are proven. Condition number one, there must be a proof that the person was mentally unsound, delirious, or illness, or they are extremely drunk at the time of contracting. Condition number two is when the other party knew about the condition. So if the other party knew the condition or should reasonably have noticed the condition, the contract becomes voidable at the option of unsound party. If the other party had no idea, means the contract remains valid. Okay. So let's look at Imperial Loan versus Stone. Okay. So the fact of this case is that Stone entered into a contract. Later, he claimed he had mental disorder at the time and wanted to cancel the contract. Okay. The court says that, okay, a contract made by a person of unsound mind is not automatically void. It is voidable only if both conditions are satisfied. The person was mentally unsound at the time and the other party knew about the unsoundness. Okay, so simple summary for you. Contract Act is silent, so court uses the English law. Contract is voidable, not void. Contract is voidable only if the mental disorder or drunkenness can be proven and the other party knew or should have known. This is according to case Imperial Loan versus Stone. Okay, under the Malaysian law, it is clearly treat such contract as voidable. Okay, so interpretation based on the Contract Act. Okay, under Section 10(1), contracts are only valid if the parties are competent to contract. Under Section 11, he says a person is competent if he is 18 years old, of sound mind, and not disqualified by any law. Means if a person is not of sound mind at the time of the contract is not valid. This is under Section 10, Section 10, Subsection 1, and Section 11. Therefore, Malaysia suggests that such contracts are void, not voidable. Okay. Next, the last one. Okay, talking on the contract by disqualified person. Okay, besides being a minor and a person of a sound mind, they are categories of people who are disqualified from entering into contracts either partially or completely. Okay, any contract made by this person or with this person is void. This means such contracts have no legal effect and cannot be enforced. So who are disqualified person? Here are some examples. Okay. Number one, alien enemy. An alien enemy means person from a country that is at war with Malaysia. During war, they cannot enter into contract because it goes against the public policy or the performance of the contract may benefit the enemy. Okay. B is statutory cooperation. A statutory corporation is a body created by law. This corporation can only do what their memorandum, act, or statutory powers allow. If they enter a contract outside their power, the contract is ultra virus. Okay, means beyond their legal power, and therefore it is void. Okay. So next one is municipal bodies. Municipal council or local authorities also have limited statutory powers. They cannot enter into contract that fall outside their legal responsibility. If they do, the contract is void. Next is insolvent. Insolvent means a person legally declared bankrupt. Once declared insolvent, their property is taken over by official, receiver, or assignee. They lose the power to deal with or contract over their own property. Contracts involving their properties are void unless approved by the receiver. The last one is convicts. A person undergoing imprisonment cannot enter into a contract during the period of their imprisonment. They are temporarily disqualified. This incapacity ends when the jail terms expires or the convict is pardoned. Okay, so that's all for this particular chapter. Thank you very much.